Hi, and welcome to another Cordell Cordell Town Hall. This month, we will be discussing how to combat false allegations when going through divorce with three of our Cordell Cordell attorneys throughout the country. Cordell Cordell is the largest domestic litigation firm of its kind, advocating for fathers before, during, and after divorce. With 30 years of experience in all facets of family law, we are truly a partner men can count on. Stick around for our Q&A section where we will have our attorney panel answer live viewer questions. Please make sure to submit your questions through the Q&A or chat section. Remember, you can also send questions to townhalls@cordelllaw.com so we can include your questions in our next segment or podcast. We will also be answering even more of your questions during upcoming podcasts on Cordell Cordell's Men's Divorce Podcast resource. Don't forget, Cordell Cordell is also providing virtual consults to help those of you going through divorce, but needing to do that in a safe environment through your cases. The important part, too, is we have a disclaimer. An attorney-client relationship is not being established here through this webinar. We encourage you to contact one of our offices directly if you're in need of legal advice. So let's talk to our panelists. First up, we have Kristina Cervone. Kristina is a lead litigator in our Scottsdale, Arizona office.
Hi, I'm Kristina Cervone. I've been with Cordell for over 7 years. I've been practicing law for over 11 years, and I'm also licensed in Arizona and in New Mexico. And a fun fact about me is I'm a veteran of the United States Army.
Kristina, she's also extremely knowledgeable. I'm looking forward to hearing her input today. Next up, we have Bennita Bullett, who's also a lead litigator from our Raleigh, North Carolina office.
Good afternoon, everyone. Bennita Bullett. I practice in Raleigh, North Carolina. I've been with Cordell for over 5 years. I've been practicing family law for about 13 years. I'm also a garden ad litem. Fun fact about me is I enjoy cooking.
Thank you, Bennita. And last but not least is Samuel Patry, who's also a lead litigator out of our Louisville, Kentucky office.
Samuel Patry, I've been with Cordell since June of 2015, so I'm approaching my 7th year also. I've worked in some of Cordell's Ohio offices and also now in Louisville, Kentucky.
Thank you, Sam. Also very knowledgeable. Looking forward to hearing what all of you have to say today. I'm Dorothy Walsh Ripka, one of our litigation partners, and next week I'm celebrating 19 years with Cordell, and I've been doing family law for 22 years now. Before we get started, we're going to take a quick commercial break, and then we'll be right back with you guys.
For many men, divorce brings a bewildering sense of loss. After years of commitment and responsibility, you find yourself alone, like you're the only person in the world. But you don't have to walk through this alone. We can help. For more than 30 years, Cordell Cordell has guided men through the challenges of divorce. You're not alone. Call Cordell Cordell, a partner men can count on.
Welcome back. Today we are talking about a very important topic in our practice, one that's also really in the news right now, which is how to combat false allegations in divorce or in relationships. And one of the things that we thought was really interesting and ties to our world very tightly, and hopefully not some of yours, but I suspect many of you are struggling with this same issue. And so looking at Johnny Depp and Amber Heard being in the midst of this $50 million defamation trial that centers really around her 2018 Washington Post op-ed about domestic violence. And without naming Johnny Depp, she essentially named Johnny Depp. And she made those claims, and because of those claims, she says that he damaged her career, or he says that she damaged his career. And so while that might not be the situation you're dealing with in your life, but you may be dealing with how false allegations impact you. So we're going to talk about it a little bit more on a base level as well. So this case raises issues for us going through divorce about allegations that are false about an abuse or neglect. And oftentimes those are false, and they are for the purpose of advancing litigation. So first, I'd like to turn it to Bennita, who's going to talk to us a little bit about the facts and how we present those to the fact finder, which is usually our judge. Bennita?
Thank you, Dorothy. Absolutely. Look, you must find the facts for the fact finder. The fact finder is that judge or that jury that's hearing your domestic case. It may not be a 50 million lawsuit like Depp. However, there's a lot to lose. Your livelihood, your reputation. You can lose custody of your children. You can lose property. And so it's so important that you gather evidence in order to disprove, to fight false allegations that it will come up. And so ways of doing that are actually, what I like to say is, before everyone files civil actions and before everyone is ready for litigation and trying to gather evidence, look at evidence that exists beforehand. Find those text messages, find those emails from your wife, from opposing party, which actually are true about you. And that could be, something saying, hey, Dave, thank you for staying up late with the kids last night. Hey, I can always count on you. Just wanted to stop by to say I love you. Thank you for allowing me to have me time and taking care of the kids. I remember a case, and it was a dad who actually held on to every Father's Day card. And this was monumental, because in the Father's Day, it just wasn't what was published by that author, but wife had actually taken the time to handwrite notes in. And I remember honing in on that to the fact finder. She went above and beyond to depict him in a favorable light. That's true evidence. That's way of combating allegations that you're a horrible father. Some other examples could be wedding anniversary cards, letters from her or, your children, text messages, emails, pictures, videos. Oh my goodness, we're in a world where social media technology is everywhere. Even if it's something you haven't recorded, it's being recorded. Use those to depict any extracurricular activities you have attended. Some dads completely forget that they actually are the ones who coached for their children. Being able to show any type of document to show that you did that, it's monumental in fighting allegations of you being an absent father, of you not being capable and able to get the children to extracurricular. So i.e. you can't have joint physical custody. Pictures, videos depicting vacations taken by the family. Birthdays, dad being present at the birthday party, pictures of dad setting up the birthday party. Sign-up sheets, signing in a child to and from daycare or summer camp, signing out a child from summer camp, daycare. It's you who's doing that. Again, that combats you not being present. That combats mom arguments saying, I was the primary caretaker. I was the only one to get them to and from daycare and school. That's extremely helpful. Another unique idea I had was where wife alleged that, she did all the grocery shopping, right? And so there would be no way for dad to even know how to do that. And so we went a little above and beyond, and we were actually able to subpoena some of his, VIC records, right? Where it's actually him using the VIC card, using that MVP card. Again, that may be a little costly. However, if you're again trying to combat, then it's worth that cost. Sam is going to highlight this. Kristina will highlight a little more on it. When there are the allegations that are also common of you being a physical abuser, right? That's going to come up. So you need to have evidence such as if she alleges in that complaint, like a date, right? So if she says, around July 2nd, he punched me in my eye or he punched me in my arm, try to find pictures around that social media time where she posts to see if there's the lack of bruising, right? That really helps. So pinpoint, the date and the location of the allegations. That really helps. Third-party testimony, it's monumental. So when I say third-party testimony witnesses, that can be your neighbors. That can be coworkers. That can be people that go to church with you. That could be fellow parents that are on those, sports teams with your children. People don't even think about this. I've used in a lot of cases exes. I just have, especially when there's a positive relationship. And I know that person can firsthand acknowledge dad, father lacking that abuse and combating that allegation of him being a narcissist, of him being, physically abusive or emotionally abusive. If you come across financial abuse, Great evidence for that is actually showing credit cards, right? Showing where she is the one making the purchases. And it's back-to-back purchases, because a lot of time it's a financial abuse. That person does not have the freedom, the liberty to do that. That's another key way. I always advise, always go to court with an attorney. When I do have clients that do voluntary assessments, that can go wrong. So do have an attorney, but for some of my clients, when there are the allegations of alcohol abuse or drug abuse, why not go ahead and undergo an assessment, right? To show that no, that's not the case. That's not true. Be very careful though for psych evaluations, because it's like candy now. I think everybody has some type of mental health diagnosis, whether it's depression or anxiety. Not saying that having any mental health diagnosis is a negative thing. Untreated mental health is the issue. And so you say, so if she says that I have untreated mental health, how do I combat that? Oh, you can, if your pharmacist is Walgreens, you can actually get a printout history of being able to pick up your prescriptions, right? What a creative way. If she says, he's an alcohol abuser, take pictures of the refrigerator of, wines that you wouldn't drink. So if you're not drinking wine, who's drinking the wine, right? Those pictures, those social media posts are her drinking. It's not bad to drink. It's the alcohol abuse, right? And so when you're able to level the playing field by saying, hey, everyone, we're both drinking, but it doesn't mean that I'm not fit and proper to exercise custody, then you need to use that. Again, any witnesses that you've confided in, friends, coworkers, hey, look, me and Tiffany had a bad argument last night. She went off the rails. She slapped me. I had to grab her hand. A lot of people forget that, a lot of men don't document, right? So a lot of women journal and document, but a lot of men forget that they may tell a friend, they may tell a coworker of an incident that occurred. Use that person to corroborate your position of not being the aggressor. You can use voicemails, text messages from wife, opposing party, showing like she is the aggressor. She's the abuser. Kill yourself. Die. No need to come home. These are things that you have to be able to show to combat. No, it's not me, it's her. Any evidence you have of attending parent-teacher conferences is vital, especially if the allegation is, I've been the only one, in charge of the academics. He can't have joint physical custody. So being able to show that, no, you are present at IEP meetings, and usually in those IEP meetings, at the very top, it says attendees. That's very astronomical in combating you being an absent father, you not sharing in the legal decision-making of the child, right? Because it's not just physical custody, there's also the legal custody. And then for some cases, you do need to get experts in. You need to get those custody evaluations in, right? That's extremely helpful in combating allegations that you're not fit and proper, or that you're abusive. And again, those psychological evaluations can also be extremely helpful. One last point is your social media post, right? Your social media post showing lack of cheating, right? Showing lack of me being drunk, showing lack of me not being present. All those things are monumental in helping to combat these allegations that are going to come up in a divorce.
Thank you so much, Bennita. A lot of good tips there, a lot of good advice. Next up, we are going to talk a little bit more about the frequent false allegations in divorce, and I think Samuel and Kristina are going to share the honors.
Yeah, and so a lot of the things that Bennita's brought up are great pieces of evidence. And when we're talking about false allegations, we're really talking about 4 general allegations that we typically see in these types of cases. The first one is usually domestic violence. Especially in custody cases, we will see allegations of sexual abuse. I'll be hitting up on those 2, and Kristina will be hitting up on the other 2, which are allegations of substance abuse or allegations that someone has a mental health issue, which is problematic and should prevent them from having custody or parenting time. And all of that great evidence that Bennita discussed and talked about, I think we should ask ourselves, if you're on this webinar, you should ask yourself this very specific question: when should I start to compile this evidence? And the answer is now. If you're at this webinar or you're looking into this YouTube video, you should be asking yourself, have I begun to collect evidence, and have I begun to protect that evidence? I can't tell you how many times I've had a client who's had, a treasure trove of evidence, and it's gone missing, right? So in terms of collecting the evidence, you want to do that, and you want to do that right away, but you want to protect that evidence. And the way you want to protect it is by saving it on removable drives. You want to make sure that you're storing this stuff, in places where, your wife won't have access to it. You want to protect it from weather. You want to protect it from vermin infestations, insects, things like that. You really want to put it in a safe place, and you want redundancies in place because that's how important this stuff is. And if you haven't started to think about collecting evidence, there's some warning signs that should be tipping you off to this, right? Your wife may exaggerate what goes on, or your husband may exaggerate what goes on in the fight, and say something to the effect of, hey, don't yell at me, or don't scream at me when you just slightly raised your voice, or you accidentally bump into them while you're walking into the home. Don't hit me, or don't push me. Things of that nature should really get the hair on your neck standing up, and for you to start evaluating whether or not you need to start to protect yourself. Now, some of that evidence is not going to be present, right? You're not always going to have pictures available to show that your wife didn't have injuries. Some of those Facebook pictures, or those Facebook posts, or Instagram posts and pictures are going to go missing and deleted after things start to get sour and after she talks to an attorney. So what you're going to want to make sure is that you obviously do it as it's popping up and keeping a safe place, but there are other things that you can do. One of the things you can also do is what's called a recorded recollection, and that's in essence a log. The law understands, and judges understand, the fact that you're not going to be able to remember every single thing that occurs in your life. You're not going to remember every single date, every single person that was present, specifically what occurred with detail. However, because of that, contemporaneous logs that are kept at or very closely to the time of an event, which in essence puts down who was there, what day was it, what time was it, what happened in a log. That log that you keep as life goes on, as the days pass, as the months pass, you can log the fact that you were at that parent-teacher conference. You can log the practices you went to. You can log the times that you sat reading with your children or helping them out with their homework. You can keep all of that into a log to rebut any false allegations. If you need witnesses, you're going to be able to log their names there. You're going to be able to know who can assist you in presenting evidence. Additionally, the great thing about this log is, because of the fact that you're not going to be able to remember all of this, you can, to a certain extent, sit on the stand and read your log to the judge. On this date, this happened. On this date, this happened. On this date, this happened. And that's typically very convincing to a judge, because they know that you took those notes at that time, and you're not likely to fabricate it. Now, a lot of people think, well, I can just put that together in the future. That's not the same. Number one, that log would not be admissible. Number two, you're going to forget things. Things are going to go missing, and it takes a lot of time to do. So if you're doing this, do it as it's happening. I would also recommend that you do this on an old notebook. Just paper is a lot more convincing to a judge than a computer printout of what you kept on your phone or on a Google Doc or whatever it is. When you have a notepad, right, or a spiral notebook, and it's got, the dog-eared corners, it's got copy stains on it, the different types of ink, your handwriting is going to be slightly different every day. A judge can view that recorded recollection and says, you know what, this was in fact taken at the time. I can trust this. I can say that this is in fact evidence. That's going to hold a lot more weight to a judge. It's going to be a lot more convincing than something that's been printed off of a screen. Now, there are some applications out there that will track real time when you actually put in certain notes. And if you have those applications available to you, you should really talk to your lawyer about your jurisdiction and the judges and the courts there and whether or not they would accept that. but those are also pretty convincing. In terms of protecting evidence, you're also going to want to make sure that you keep informed as to whenever there's any medical appointments for your child, and those records and things that they're said, you're going to want to make sure you document and compare what was said at the appointment versus what took place or what was placed in the report. And if something's left out that's important, you should very politely make sure that the record is accurate, because those records are going to be king in any future hearing. At this point, I think that I'll go ahead and pass the mic over to Kristina so that she can dive into substance abuse and mental health issues.
Thank you, Sam. I really quickly, regarding the notes that you were just referring to, I actually tell my client, I call it a daddy log. And I tell my clients basically the minute they hire me that they need to start tracking create their daddy log. It's similar to a diary, but, and you keep doing that, and you do it past litigation. Once the divorce is finalized, you keep that log going until your last child turns 18 years old, because unfortunately, sometimes things repeat themselves and you might be in litigation more often. And those daddy logs are amazing, and they are such great evidence. So thank you, Sam, on that point.
I know you indicated, Kristina, you start them when they hire you, but it's never too early to start those daddy logs.
Yes, if they haven't started it, then I tell them to start it. If they've already started, I tell them keep going, and you keep going until the youngest child is 18 years old, because you just never know when you're going to need it. And it's a great habit to get into as well. Some of the other things that we want to take advantage of too, like you said, are pictures. One of the things I tell my clients as it relates to potential domestic violence, Arizona is a one-party consent state as it relates to recording. So you want to check your jurisdiction to know what the law is as it relates to recording your conversations. But I know in Arizona, we're a one-party consent state. So I tell my clients to start recording interactions, especially if there's any hint that they might be making allegations of domestic violence. I tell them to just have that recording on them at all times, but only to make sure you record only when you're having that conversation with her. You can't record her conversations with other people. But again, check your jurisdiction on what the laws are as it relates to recording conversations before you start doing that. But if you are in Arizona, one-party consent. Don't record if it's interstate, but I think we'll be getting into that later. As it relates to substance abuse and mental health issues, when you have an allegation of substance abuse, a lot of times, at least in Arizona and New Mexico, what will follow is they'll ask the court to do random testing. They'll ask for hair follicles if it's a drug abuse allegation. And what I tell my clients is if you're innocent and you're not an alcoholic and you don't abuse drugs, then we're going to just, yes, we'll go take the hair follicle. Yes, we'll submit to random drug testings for a limited period of time. And then you make sure, of course, that you don't drink alcohol during that time frame. You don't do drugs. In some states where marijuana is legal, I actually tell my clients, even if it's legal in that state, to stop doing marijuana as well throughout the proceedings, because it just helps strengthen the case that you're not abusing any type of substance. I tell my clients also to avoid drinking, even if you're not being tested, or alcohol tested. I tell them to just not drink at all during that time frame. It can be hard sometimes to combat those allegations without doing random drug testing or random alcohol testing. There are some places where you can go and they will actually do an alcohol assessment to determine whether you have the propensity to be an alcoholic. Sometimes I will have my clients submit to that as well. But the more that you can basically call the bluff and say, no, I'm not, and here's how I can prove that I'm not, it's always the best thing to do. I like the idea of taking pictures of your refrigerator. If you're not a wine drinker, but wife is a wine drinker, show those pictures. I've had that come up recently in a case where mom was drinking all the time, claiming dad was the alcoholic. We had all the pictures and we could show that she was the one drinking the wine. We had actually a video of her drinking wine in front of the children the day after they agreed to not drink in front of the children. Those things are very useful and help to combat that. When it comes to mental health issues, this one I think is a little different in a sense than some of the other allegations. And it does come up quite often. And for me, at times, it's actually something that it can be near and dear to my heart, especially if somebody tries to claim that the father or a veteran has PTSD, which happens a lot. Mother will claim that the veteran has PTSD when in actuality they don't, or they do, but it's not the type of PTSD that you would think it is. There are other types of mental health issues that get asserted. You know, they're bipolar, they're narcissistic, they have borderline personality disorder. The only way to truly combat those, if you haven't been diagnosed with those, is ultimately to see if you're willing to submit to a psychological evaluation. You want to try to make that somebody that you choose. You want to make sure that person is reputable, that the person has, you know, a doctorate or a PhD or a doctor, because believe it or not, I don't know in other jurisdictions, but in Arizona, we have some people out there that will conduct them that aren't actually licensed or have the ability or the knowledge to be able to actually do an accurate psychological evaluation, but those come in handy. If you have been diagnosed with PTSD or depression or any of those things, then realistically, the best way to combat those allegations that it's interfering with your parenting time is to show that you are compliant, that you are going to your therapy sessions, you are taking your medication. And how do you do that? Through pharmaceutical records, getting letters from your doctors. I'm not really an advisor of getting your mental health records and producing those to everybody, but if the court requires that or wants that, then I always recommend that you make sure that there are strict things in place, that those records don't get handed over to the other party, and then it's just the other party's attorney that's maybe seeing those records, and putting in basically things in place to prevent everybody from being able to see those and to have those sealed. I think that, again, having a mental health issue doesn't in and of itself prevent you from parenting. What the court is going to look at, does it interfere with your parenting? Does it interfere with your ability to make legal decisions for the children? And if you can show that it doesn't, then you're fine. You shouldn't have any issues.
And I think there's a tendency that, you know, some people may think, oh no, I have a diagnosis for a mental health issue. And one way to combat the allegation, right? The allegation isn't that you have a mental health issue isn't going to disqualify you as a father or a mother as a parent, right? The allegation that mental health diagnosis and what your condition is interfering with your ability to parent, that is the false allegation that we must refute. And so human nature is to either become defensive or hide from it or lie about it. But it's important that if you are diagnosed with a health issue, that you don't hide from it. You can actually demonstrate, look, yes, I've been diagnosed with PTSD, or I've been diagnosed with depression. I've been diagnosed with anxiety. However, I'm seeing a mental health professional. I'm taking my medication. And I'm doing all the things that I'm supposed to do. And guess what? It's not impacting my life because I'm getting treated for it and the treatment's working. It's no different than any other mental or physical health condition, which might prevent someone from being able to parent. As long as you're doing what you're supposed to do, you're going to be fine.
That's where Bennita's information comes in, because taking that and polling, well, mom has PTSD or dad has bipolar. Well, you didn't have any issue leaving them at home while you took a trip to Vegas for 5 days, or you didn't have any issue with him being the person that, you know, or her being the person that took, to school every day, picked up, volunteered, chaperoned on weekend trips for soccer. And that kind of evidence helps you refute it. And one of the things that we're hearing today is a lot about timing, right? When to start doing this. Kristina and Sam and Bennita have all said, start now. Sam makes a great point. If you're watching this, start now, if you haven't already started. And you need to think about defending these false allegations in the same way. We want to help you use it as a shield, but also maybe as a sword. Because if you have someone that makes false allegations for an attempt to get a leg up in litigation, courts don't like that. And so if you can show, hey, these are false allegations engineered to fool you, judge, that helps us do our jobs as divorce attorneys too, because we can show the court, not only are these allegations false, so I should have all the time I'm asking for with my kids, but maybe you should turn and look at the other parent a little bit too, because that's concerning that they're placing their desire to win in litigation ahead of the best interests of the children. Sorry, Christine, I interrupted you. Back to you.
No, I was just going to say, it's kind of actually off what you were just saying, was just that sometimes too, when we're dealing with certain types of mental health illnesses that you may have, like PTSD, sometimes you're actually needing to educate the judge. And so sometimes you'll bring in mental health experts, not just the person who diagnosed you, but maybe somebody else that's totally independent who can come in and explain those things. So again, getting back to Sam's point of not hiding from it, because there are ways to educate the judge, right? I use PTSD as an example, specifically tied to military, because that is one of the areas that I'm pretty familiar with. A lot of judges and a lot of people in the general and juries think of PTSD in the military as anger issues and alcoholism and things of that nature, but that's not true. Most people with PTSD are not angry, don't have anger issues, aren't alcoholics, and that's just educating everybody and educating the judge to help them to understand what the mental health illness is, what that means, and how it isn't affecting your ability to parent. One thing also to keep in mind with all of this is that half of our battle is whether or not the judge is going to like you. And that is just the bottom truth. When we're dealing with divorce, when we're dealing with custody issues, it's going to be who do the judge or the fact finder like the most. And I think the Johnny Depp Amber Heard case right now is a prime example. You can see how everybody is just running and jumping and just swarming around Johnny Depp because everybody loves him. I mean, he's Johnny Depp, right? He's Jack Sparrow. I don't know if he was abusive. I don't know if Amber Heard was abusive. I don't think any of us are really going to know that because we weren't there. But you can see that in this particular case, everybody loves him, and he appears to have a leg up from what I can see because everybody loves him and everybody seems to not like her, and so when you're thinking about, that type of thing, you want to think about, how are my friends perceiving me? How to tie that into you. How are my friends and family seeing me? How is her family see me, right? So you want to maybe repair some of those relationships if you've had bad encounters so that they don't get twisted around and turned around to make you look like a monster.
I always tell all of my clients that every person that you interact with prior to your divorce and during your divorce is either going to be a witness in your column or a witness against you. So it's so important that even in high conflict situations, and this is my rule of thumb, number one, slow down. When you're under the gun, when you're under stress, when somebody's coming at you, the general reaction is to either run or fight. Both of those lead to very hasty thinking, and things are said in haste. Don't be afraid to slow down. Don't be afraid to take a breath and then slowly reason yourself through it, and then give a very calm and slow response, especially if the police are called. If the police are called, the person who's the calmest and most put together person is typically the person law enforcement's going to believe. Even if she's done the most outrageous thing to you, it's important that you keep your cool, because those recordings become evidence. Those officers become witnesses. Same things with schools, same things with doctors, same things with her family members. Be very careful in the way you interact.
I was going to pull in to Kristina's point. If you have been following the Johnny Depp Amber Heard trial, they actually used a psychological expert as a sword, in the sense to say her behavior is so erratic and off kilter and crazy. And here's why. We have a diagnosis for her. She doesn't have a diagnosis of her own. She didn't come with evidence saying I have a diagnosis. So they brought a doctor in to say she suffers from histrionic and narcissistic personality disorders, which explains a lot of what he's telling the court are the behaviors he's viewing. So that's what I mean when I say we're using it as a sword, in the sense that it's supporting our case. A lot of times in our world, we use it as a shield because an allegation is made, and we could bring in a psychological expert to help defend our client being attacked by it. So again, to the point Kristina made, we may be looking at a psychological expert that is someone who you use as your treating physician or therapist, but we may also ask a third party to come in and give an objective evaluation to explain why something is inappropriate or incorrect, and help in your case. So I want to make that clarification.
Dorothy, if I could say this, I know we're giving like a long laundry list, like the best day in court. But I like how you just pointed out, Dorothy, the turning point for me in the Johnny Depp was the expert. So for a lot of the cases, if you're fighting and combating an allegation, it's credibility, right? So if you have a finite attorney, i.e. Cordell attorney, attacking credibility on one issue is monumental for all issues, if that makes sense, right? And so you may not have the daddy log, you may not have the pictures, you may not have the text messages, but if it's just that one witness who can attack some of her testimony and allegations, for the fact finder, it applies to all other allegations, if that makes sense. And so I did want to throw that. I mean, we're giving you an idea case. As an attorney, a lot of times I just don't have people because we're busy with life that can do all these things. The daddy log is phenomenal. Some of my clients, I just say, look, go to Walmart, go to Target, get a 12-month calendar if that's easier for you because it's already dated. You just put on there May 2nd, mom was 10 minutes late to the exchange. You know, it was time for me to have my time and mom text messaged me saying no, right? So as Sam said, courts like recorded recollection, courts also like everything in one spot. That's why that calendar is key, because we can just flip and keep showing, the pattern of mom to attack credibility. So I just want to throw that in. Again, we're giving you an idea case for an attorney. Also want to normalize mental health. Okay, as attorneys, as judges, we're required to undergo these, continuing legal education classes. So judges are being educated. You have to remember, judges are people, juries are people. And so we all know a sister, a aunt, a cousin, a coworker that has a mental health diagnosis. As everyone has pointed out, though, it's the treatment of it. Don't hide from it. It's the norm. And remember, the judge also may be on some Zoloft, right? And so, normalizing mental health and not running from it, it's key. It's monumental to your case and your credibility.
I agree. And I think the one other current that's running through what all of you have said is presentation to the court is so key. As Sam said, being calm, being collected, being organized, having your information, and sometimes owning up to faults. I always tell clients, I'd rather you said where you have a weakness than have opposing counsel cross you on that issue. So when you're, when those of you out there listening, when you're talking to an attorney, you have to be open and you have to say, I have this in my past, or I have this history, or I have this diagnosis, but I don't like how the medicine feels. I don't want to be on it, and you have to be open to understanding. Your attorney might say, you have to go back and talk to the therapist. You have to follow recommendations. You have to be prepared to show the judge that you're the reasonable one who's putting the children's best interest as a tantamount thing. And that's hard. And we know we're asking a lot of our clients because, as one of you said, who has time to do all of this and be a great parent and document? But we ask you to do that. And we also will help you provide tools. And, any attorney that you meet with will help you share their experience of how to present that to the court in a fashion where it's not only organized and credible, but persuasive, so that the court understands your position and hopefully is inclined to rule in your favor. We're going to go to a few questions now. It's gotten to be that time. First up, I'm going to have Sam answer a question. The question submitted was, my wife made false allegations about me during our divorce, but unfortunately I couldn't prove she was lying. I later discovered evidence proving her claims were untrue, but now our case is over. Do I have any options or recourse, or am I just out of luck?
So generally speaking, in a fact pattern of that, there are two ways in essence to be heard on what we would call newly discovered evidence. They're pertaining to the civil rules. Now, most states have adopted the federal rules to a certain extent. You're going to have to check with an attorney in your jurisdiction. But generally speaking, per those rules that have been adopted by the states, there's a civil rule called Civil Rule 59 and another Rule 60B or Civil Rule 60. The first rule says, hey, I need a new trial judge, and I need a new trial because I've discovered evidence and the court should hear it, and we should hear this specific issue or sometimes the entire case over again. And you have 28 days after the judgment on that, most jurisdictions. But you have to check with your lawyer in the jurisdiction you're in. The other case, the other rule is similar, but instead of asking for a new trial, what you're doing is you're saying, as it pertains to this specific order, I need the court to give me relief from that order because of the fact that I've discovered new evidence. Typically speaking, that's going to have to be filed within a year, and there's very specific reasons. But what it all comes down to in these discovered evidence after the trial is whether or not that your attorney or you could have reasonably discovered that evidence if you took some steps to do so. For example, if you have medical records that you discovered after the case that were in existence prior to the trial, then the judge is going to say, shame on you, you should have brought it to the trial. But if she deleted evidence or hid evidence or lied to an investigator or something to that effect, then you might be able to get it before the court if there was some reason as to why you could not have reasonably anticipated that it was out there and presented it to the court.
Kind of along those same lines, Kristina, there was a question that was put out there also from a potential client here. If I am able to prove my ex is lying, will there be any consequences to her?
And that's a good question. I find, at least in my jurisdictions, it's very rare that the court is going to hold her under contempt. However, as we were talking about, or as I was saying earlier about whether or not the court likes you or not, this is one of the ways you get the court not to like you. So if we can prove that she's lying, and we can discredit what she has presented to the court, that is very powerful because it shows that her testimony is not trustworthy. And usually says basically most of her testimony, if not all of her testimony at this point, is not trustworthy because you've shown that she has the ability to lie to us. Technically, a court can hold her under contempt if she was found to have lied to the court under oath, but I find, at least in my jurisdiction, usually that doesn't go anywhere. However, I usually find that when I prove that the party has lied to the judge and called the credibility into question, I find that I'm more successful in those cases when it comes to the issues that are being asserted, especially if it's some type of domestic violence or alcohol abuse type of allegations. Usually they're found not to be present when we can prove that she's lied on the stand.
And I think that rings back to Sam's topic. There are ways to prove that depending on the timing. They may require special motions. Alternatively, at the time of the final hearing on the matter, you can do it in the form of in-court testimony, or even back to Bennita's situation of finding documents that support that there was an untruth by mom in this situation. Next question is going for Bennita. How careful should I be if I have a recorder that I'm using when my wife and I are in separate states? I'm worried that laws could differ from state to state. So kind of to Kristina's point earlier about recording, but in this situation, what if it's across state lines, Bennita?
Absolutely. And it's good to have that here, right? Because you need to consult an attorney regarding the recording laws. And so although it may be you in one state, mom or wife in another state, the court that the matter is pending, right? That court has jurisdiction. So let's say, for instance, you live in Arizona and mom lives in California, okay? And the custody action is pending in Arizona, right? And as Kristina has already let us know, Arizona is a one-party consent state, right? So that recording is fine. However, if the action is pending in California, I can tell you, I don't know California law, but they have some of the most crazy, complex exception to the exception laws. That's why it's important to have an attorney who knows the California recording laws, because in California, it's based upon the type of recording, telephone, versus in person, whether that communication was public, or was it done in private? So it can be very complex depending upon the recording laws in that state. So it just depends on whether or not you can use it based on that specific state that has jurisdictions recording laws. And so North Carolina is a one-party consent state, no matter the type of recording. But again, it could fluctuate just depending upon a specific state's laws. And for Kristina's question, I guess we can all wait. If Johnny Depp gets $1 million for this defamation suit, absolutely, there are consequences to someone lying and making these false allegations. Absolutely.
And he's asking for 50 million. So let's see what happens, right? Okay, there's another question for me. And this one, there's a bit of a factual scenario that I won't go into on here, but essentially the person is asking when there's been a history of allegations of domestic violence for the past 6 years, and now and the parenting time has been limited, how do they go about expanding parenting time, getting overnight, combating these false allegations that just sort of keep coming up? And I think we've talked quite a bit on some of the things you can do in that scenario, which is you start to try to prove the negative, which is a very difficult thing to do as a person and very difficult as an attorney in court. But essentially, the best thing we can do is show your skills as a parent and the things that you've done to advance your skills when you have, as this person indicates, no history of conviction and no prior domestic violence order issued. Just that the judge sort of buying off on there seems to be something there. The best thing you can do is increase your skills as a parent. There are parenting classes out there. There's assessments, as Kristina mentioned. You can proactively go in and be assessed for domestic violence. Find someone who can be your sword, your witness, to tell the court these allegations are untrue, and I have evidence that supports how fit I am, and that I don't have anger issues and I don't have domestic violence issues. And recording your recollection with other objective third-party witnesses, other pieces of evidence, as Bennita has pointed out, things that show you've been a good parent, a good person, someone that there's been no domestic violence or concerns thereof. And again, if there's already a court order that says in 2016, these were the concerns, here's what we're doing moving forward, the change in circumstance you're showing is what's happened from 2016 forward. So that's really the onus on you as the parent wanting more time, looking at how can I show that I'm fit to have more time with my child or children in this case. And so again, from a strategic perspective, I would probably have the client come in, get them hired, and do all these things before filing the motion, because the time to start is before you're going to court, not when you're going to court and then, I'll take this class, or I'll read this book, or I'll have this witness come in. You want to start that really well in advance of going to court and asking for more time. So, kind of taking into consideration really all that we've talked about today. Okay, well, I think that's it for today, unless anyone has any other points they'd like to add. We want to thank everyone for joining us today. We really enjoyed this topic. As Bennita said, that it's a sensational topic, but on a real level, we know it really impacts, those of you watching on a very real basis. So, again, we recommend you get help if you are needing some consultation on this issue. But again, visiting CordellCordell.com, call us at 1-866 Dad's Law, so you can be in contact with one of our Cordell attorneys that are near you. As I mentioned at the beginning, don't forget about our virtual consults or to visit our Men's Divorce podcasts. And this live webinar today was presented and produced by Lexicon, a legal technology company. And all of us here at Cordell Cordell really appreciate you today and hope you have a great day. Thanks.